versus, and I apologize if I mispronounce the name, Siddharth, Breja?
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 I guess they can tell us.
I'm sorry if I mispronounced it.
Oh, we need to wait for Mark.
Yes. I have a leaky pen.
Oh, no. You need another pen?
No.
You
Well,
okay?
yeah, you know what? This one's leaking. Thank you.
You're welcome.
Okay, I believe the parties are here.
The party's appellant's not here.
Oh, the appellant is not here?
He's not here. I think he's going to a doctor appointment, Your Honor. He thought he wasn't required to be here personally, but I'm the counsel for appellant.
I'm sorry,
I am the counsel for appellant.
you were the attorney?
Yeah, I am.
Oh, okay.
I substituted into the case yesterday afternoon, so that's
All
why.
right, I don't believe he has to be here, and you have substituted in, is that?
I
correct?
have, Your Honor.
Yes, I believe we did receive notification that you have substituted in.
I did, yes.
Okay, let's call the matter again at line 4. Andrew G. Waters versus, and
Breja?
okay, thank you. May I please have the parties state their appearances for the record?
Good morning, Your Honors. Andy Liu, counsel for appellant, Breja.
Jeremy Stone for plaintiff and respondent Andrew Waters.
I am Justice Terry L. Jackson. I am the presiding justice of Division 5. I am joined on this matter with Justice Mark Simons and Justice Danny Chu. I believe the parties have received an order from this court, and the order sets forth that each side will be given 10 minutes. And in this order, I believe the parties have been instructed that the respondent will argue first, and there will be no rebuttal in this matter. So with that, this is an appeal. Oh, just make sure I have it correct. From an order denying the motion to dismiss a complaint of the plaintiff and to compel arbitration. So, respondent.
Thank you, Your Honor, and may it please the court. The court should uphold the trial court's ruling here.
Counsel, you can raise the podium if you'd like. There's a button.
The button.
There we go.
There you go.
Could you start back at 10 minutes so that he...
Sure. It's the problems of being 6'3".
Well, I don't see any problem with being 6'3". Since I'm 6 feet and I wear 4-inch heels.
Oh, nice.
All right, let's proceed.
All right, thank you, Your Honors. The court here should uphold the trial court's ruling because the undisputed facts here show that the appellant waived arbitration by his conduct when the appellant stole $10,000 from respondent through his intentional representations to American Express, which caused respondent the harm. These same facts would support a judgment in favor of respondent on his complaint. Conversely, granting the appeal here would require a finding that conduct that constitutes felony theft under the penal code would be somehow consistent with the right to arbitrate. And such a finding would be inconsistent with California law. The appellant's appeal here is based on a mistaken belief that the trial court applied some novel procedural rules here. It didn't, and that is simply not the case. In Morgan v. Sundance, the Supreme Court stated the policy is to make arbitration agreements as enforceable as other contracts, not more so. Accordingly, a court must hold to its arbitration contract just as the court would to any other kind, but they may not devise novel procedural rules to favor arbitration over litigation. And this principle is reiterated by the California Supreme Court in Quach v. California Commercial Club Incorporated, stating that California's policy with respect to the enforceability of arbitration agreements, like federal policy, is about treating arbitration contracts like all others, not about fostering arbitration.
So, counsel, in that same Quach decision,
Yes.
it established that the standard for determining waiver is clear and convincing evidence.
Yes.
Here, the court clearly applied a prepreponderance of the evidence standard.
Yes, I understand.
Doesn't that require a reversal by itself?
No, because I believe substantial evidence here still would be would find for clear and convincing evidence because all the facts here are completely undisputed, that he knowingly took the money. He told American Express that he had met the express conditions for his contract. The contract only had one condition, which was settlement before trial. He could get a
But
refund.
counsel, didn't the trial court reject your argument that the alleged fraud precludes arbitration here because the fraud was to American Express and not to your client, and frankly had nothing to do with the agreement itself?
No, the court rejected the fraud as far as fraud in the inducement of the agreement, but not relating to the arbitration issue here.
I guess what I'm not understanding is if the cause of action is essentially fraud committed against your client after the arbitration agreement was entered in connection with a dispute over the fees, how does that affect whether there's a waiver of arbitration?
Well, it affects the waiver of arbitration because the contract was entered into first. The appellant knew that he had to go to arbitration because he was expressly told in writing and had the contract itself. After the fact, he went to American Express and told them expressly that he had met the only condition for a refund here possible, after he'd been told he was not entitled to a refund because there had been no settlement. And that fact, the lack of a settlement, was judicially noticeable because in San Francisco County, his divorce case was still.
This is where I'm struggling with your argument. Yes, you're alleging that he committed fraud in the chargeback process, but how does making a fraudulent statement in a subsequent proceeding somehow create a relinquishment of the right to arbitration? Now, let's suppose, for example, instead of arbitrating, they filed a lawsuit, and in that lawsuit, they made false statements. The fact they made false statements in the lawsuit doesn't establish a waiver. It's the filing of the lawsuit, right? So what relevance does the fraud claim have to the waiver issue?
Well, here is because the fraud claim is that American Express did, in fact, take the money off of his false representations. So my client does not have the $10,000 out of that. So even if there was a complaint is simply a notice.
Well, let's assume for purposes of argument we disagree with you on that point. What is your argument in favor of waiver here?
What I would say is the appellant's conduct here would constitute conversion under the Civil Code. So I could, if I were to file a complaint again, as we did for conversion, all the elements there are met for that. All the elements are met for intentional misrepresentation to third parties. Like, if I were to, if it was,
I think you misunderstand my question. Let's assume for purposes of argument the merits of your claim against Mr. Breja don't have a bearing on whether he waived his right to arbitration. In that situation, what is your argument in favor of a waiver?
Well, again, the argument in favor of waiver is that when he had no possible way of getting the refund, he intentionally went outside the bounds of everything and asked and told his bank that he was actually required to get this money back. I mean, that, again, that's fraud. I mean,
But isn't, sorry, go ahead.
No, I'm going to assume possibly a fraud, but didn't American Express also say, well, yeah, you're going to get the money back, but if there's a dispute, we can come back and get that $10,000 back? So, yeah, he did get it, but American Express can get it back.
They still gave it to him though before our lawsuit was initiated. So he got the money back, which triggered the initiation of the lawsuit, because there was no possible grounds for it. American Express only went off the representations of the appellant. They did not go through any questions with my client.
Counsel, it just seems to me that you confuse the difference between the merits of the dispute and the forum where those merits should be hashed out. Mm-hmm. The defendant never invoked an alternate forum, alternate to arbitration, that had the authority to determine the legal right to the $10,000. Mm-hmm. That's what would have happened if he had come into court, for example, and said, court, you decide this, then that may waive arbitration. But regardless of the merits of the claim, I'm struggling to see anything here that said he's no longer entitled to arbitration. And in response to similar points made by my colleagues, it seems to me you answer them by saying, yes, yes, but he did this, he committed fraud, he cheated us. Okay, but the question here is primarily, as I see it, is where is that going to be resolved? In arbitration or in court? And the legal arbitration agreement both of you signed seems pretty clear on that.
And I would say that, again, the conversion here, which is he took the, knowingly he was not entitled to the money whatsoever. That is, I mean, that's under the end of the penal code. That is fraud. That's a crime.
So therefore,
so
he's not entitled to arbitrate if he engaged in some civil wrong that's also a criminal violation.
I would say,
And your authority for that, which frankly, I've not seen argued before.
I mean, I would just point to the penal code. Those are the elements of bank fraud. That's a felony in this state. So I would say that in any instance, also,
So,
you know,
under your argument, could a fraud claim ever be arbitrated?
if there was not the issue here of the completed crime or the completed issue of actually stealing the money afterwards. If it had
But
just,
isn't most fraud claims involving taking somebody's property through fraud? I mean, that's the sort of quintessential fraud claim that people assert in civil cases, isn't it?
there is, but then there's also the conversion of the money, which is also a
So
strict,
can a
strict
conversion claim ever be arbitrated then?
I don't believe so, because it would be, it's being as a strict liability. It's just the simple fact of taking the money and preventing it.
So your position is that a conversion claim could never be arbitrated simply because it's strict liability? Does that mean any strict liability can never be arbitrated?
I would not say that. I would just say that based off of, in this type of specific instance, this type of criminal conduct waives arbitration because his conduct is inconsistent with invoking the right to arbitrate. When you know that you've been expressly told to seek arbitration, you choose not to. Instead, you make false statements to your bank. Tell them that they owe you $10,000, which is a felony in this state. That's the issue here, is felonious conduct clearly waives arbitration at any point. And there's the issue, again, it's
Is there
applying.
legal authority? I mean, is there a case law on that?
I don't have case law. I would just say that, the law recognizes unclean hands under the maximum jurisprudence, and that's exactly what this is here.
So this is an arbitration that's compelled by law. That is to say, the arbitration agreement is compelled by law because it involves a dispute over attorney's fees.
Yes.
So is your position that if your law firm client wanted to arbitrate in some other case, nothing here, that if the client said, well, they've taken my money, they won't give it back to me, they are guilty of conversion, then he's automatically entitled to go into the trial court, and you lose what most lawyers view as a very valuable right to enforce the arbitration agreement. That's what your firm would say, okay, well, he is accusing us of taking the money with no right to have it. So we can't get that resolved before an arbitrator. We are required to get it resolved by a jury trial.
What I would just say is that if he hadn't taken the money, if the money was still with my client and he had filed a lawsuit or sought arbitration while my client still has the money, he is free. He could seek arbitration, and that would be totally valid. He could seek litigation. Potentially, we would, not waive arbitration. That would be up to the client at that point. But the fact that he actually took the money outside of the contract, that the contracts were complete. He ended the representation completely ended. So and he understood all these things. Yet going forward, he still took the money and then is saying, hey, not only did I steal your money, but you have to go to arbitration. You can't litigate this. That's just completely inconsistent with the law.
No authority in the law have you cited so far, but it's completely inconsistent.
I would just say
with that.
it's the principles of waiver from Quach, and again, Morgan saying that that waiver applies to all arbitration agreements. And you just have to show that it was inconsistent with it. And the trial court's findings, and her own language says this clearly showed this. While she, again, found preponderance of evidence, as you stated earlier, it still would be upheld under the clear and convincing standard because that is all the evidence there. There's no evidence of anything else other than the fraud here, that he lied to the banks, took the money from my client was harmed, and now he's seeking arbitration when that's just completely inconsistent with the principles here of that.
All right, thank you very much. You've used your time.
Thank you.
Good morning, Your Honor. May it please court? The trial court should be reversed with instruction to compel this matter to arbitration. First of all, the trial court erred because the trial court applied a preponderance of the evidence standard on the waiver issue, but the case law is clear. As Justice Cho stated in the Quas case, the standard for finding a waiver is clear, convincing evidence. It's a much higher standard. Therefore, on that issue alone, the trial court should be reversed. Second of all, the backdrop in this case is a law firm is suing a prepared client for $10,000 attorney fees. The lawyer essentially is turning this small claim case into a World War III against this prepared consumer because the lawyer was not happy the consumer invoked a credit card chargeback. That's what this case is about. And as the trial court history shows, the lawyer essentially compelled discovery, informal discovery conferences. The lawyer is trying to invoke all these procedural maneuvers to pressure the client in trial court into submission. And therefore, the arbitration is especially proper. Do you have any questions, Justice Simmons?
Well, I'm interested if you're going to talk me out of my view of this case. Maybe my view wasn't particularly clear from the questions I asked opposing counsel, but have at it.
Essentially, this is a small claim case. $10,000 goes to small claim court. But again, the lawyer is turning this into a war machine.
Well, the complaint alleges that because of the taking away of the $10,000 that it had repercussions on his practice where the damages presumably exceeded the small claims amount, right? There's nothing in the merits on that. I don't know if he's going to win, but at least that's the allegation, isn't it?
Fair enough, Your Honor. I think again, the fraud/felony crime argument is exaggerated. It's fundamentally a breach of contract issue. It's an interpretation of contract. Contract says the client is entitled to $10,000 refund of $10,000 trial deposit if the matter settles 10 days before trial. The argument is somehow the deposit is refundable only if, but the word only is nowhere in the contract. So that argument alone fails because they import this word only somehow into this contract where the contract does not have the word only at all. And then it's important to note the lawyer, the law firm, drafted this engagement letter. All the ambiguities must be construed against the law firm, not against the client, because the lawyer drafted this agreement. But second of all, the argument is exactly because, it's traditionally notable. There's a professional rule about refunding unearned fees by a lawyer. Unless it's true retainer, all the unearned fees must be refunded to a client, period. That's professional rule 1.15.1. It's not in a record, but again, there's some judicial noticeable fact about that. Therefore, the argument that the client somehow committed fraud is seriously exaggerated. It's fundamentally an interpretation of a contract term issue. And then again, the contract term, by its own term, says, quote, any dispute over attorney fees should be compelled to arbitration. That's what the lawyer said. to the client, and the lawyer must be held to that standard. The lawyer cannot say after the fact, you somehow committed this fraud and misdemeanor or felony, therefore you're not entitled to arbitration. There's no such thing as Your Honor stated. There's no case law about somehow there's a felony exception. I mean, again, that proposition just encourages essentially legal maneuver, say, okay, I will make a fraud cause of action, therefore I can circumvent my own arbitration clause. It doesn't work because there's no such exception here. And again, as Justice Simmons noted, there's no case law about this. And then, again, if there's fraud in the inducing the law firm enter into the arbitration clause, I would agree. Okay, then the arbitration agreement may not be held up, may not be enforced. But again, all the alleged fraud, which is not true, by the way, all the alleged fraud occurred after the arbitration clause was signed by the lawyer. Therefore, it should go properly before arbitrator to see if there's fraud or not. There's not. But again, this goes to a matter of merit. The merit should be determined before an arbitrator, not before a court. Again, I think, secondly, there's no waiver in this case at all because all the client did was the client went to American Express under the federal law to ask for a chargeback. The American Express, as the record indicated, asked the lawyer would you please respond to our chargeback inquiry? The lawyer simply did not respond to it. The lawyer simply filed a lawsuit about it.
So you would agree then that the chargeback process did not determine the merits of whether the attorney was entitled to that $10,000 deposit or not?
No, it did not at all. The attorney simply failed to respond as required by his agreement with American Express. So he agreed to take money from American Express. He agreed to their procedure. But the lawyer failed to participate with American Express inquiry into this $10,000. And then the lawyer simply filed two lawsuits. That's just one, two lawsuits. One federal court lawsuit, and then the second, the state court lawsuit. The federal court lawsuit was dismissed because the subject matter jurisdiction was, again, exaggerated. The lawyer said, okay, so the client somehow committed computer fraud. It's the same manure. The client was fraudulent about using his computer to get a refund. The federal court dismissed that case, basically ruling that the computer fraud claim has no merit. And then the lawyer went to the state court, sued the client all over again, and then dragging the client into all this discovery motions, motion to compel, motion for sanctions, and then motion for, this and that.
Counsel, you're telling us all this stuff. I'm having trouble seeing how counsel's behavior in the trial court should lead to the answer of whether you belong in the trial court or in the arbitration. I guess you have 3 minutes and 13 seconds to continue arguing things that I'll just describe as unnecessary.
Fair enough, Your Honor. I mean, let me sum it up, Your Honor. I think the counsel's behavior is relevant because counsel is compelling the client to engage in litigation. Because once you file a motion, the client has to respond, right? The issue here is the client never waived arbitration. In fact, the client has been insisting on arbitration. He filed.
Counsel, I think what Justice Simons is saying is that to waive arbitration requires clear and convincing. And would you not agree the record is void of that?
Yes, the record is void of clear, convincing evidence, and therefore the trial court should be reversed, Your Honor. That's all I have. Thank you.
Thank you. All right. Thank you. The court has now heard arguments in this case. We've read your papers, and the matter is now submitted. Thank you.